Good afternoon, and welcome to the UCI Law Moot Court Final Round. My name is Bailey Hasbrock, and on behalf of this year's Moot Court Board, thank you for joining us. The last 2 years have been quite unpredictable, and I'm ecstatic to see the UCI Law community back together again. The Moot Court competition is one of the most unique educational experiences available to the students here at UCI Law. This competition allows students to write briefs, participate in oral advocacy, and think critically about real-world issues. Each year, the board chooses a case. Some are live cases, working their way through the circuits, and others, like the one we chose this year, is a fictional case, designed to analyze and test emerging legal issues. For many second and third year students, Moot Court is the first opportunity to apply doctrinal learning by advocating for clients against a complex record. What you see today is months of hard work, research, writing, and critical thinking. I have witnessed firsthand what my fellow colleagues have accomplished, and it is nothing short of amazing. We are thankful for the staff, faculty, administration, practitioners, judges, and members of the Orange County and Los Angeles legal communities. I hope you enjoy today's event. Without further ado, please join me in welcoming Dean Garth.
Good afternoon. This is really a signature day in the life of this law school in particular, but really every law school, to hear just how great our advocates are and celebrate their achievements. It says on my reminder of what I'm supposed to be doing here that I should thank the board. That's easy to do. The board, congratulations to them. It also says, this is a little puzzling, remarks on case and then judge introduction. I'm fine on the judge introduction, but remarks on case, let me just say this. It's quite a drama about a friendship gone bad, revenge through social media, a question of what the law can do, and then how is that affected by the First Amendment. That's the case. Now I want to introduce our three judges. I have their biographies, and they are extremely impressive, and I cannot possibly summarize them. I can tell you that they are all three pioneers in certain ways. They are all three have extraordinary careers before and during the judiciary, and they have many honors and awards that I can't tell you about because I don't have time. But I will give you some highlights just to give you a sense of who they are. I'll start with the Honorable Bernice B. Donald, who will be on Zoom. She was nominated to the U.S. Court of Appeals for the Sixth Circuit by President Obama. She was confirmed in 2011. She became the first African-American woman to serve as a judge on the U.S. Sixth Circuit Court of Appeals. Prior to that, Judge Donald was appointed in 1995 by President Clinton to serve on the U.S. District Court of the Western District of Tennessee, where she was the first African-American woman to serve on that court. She also served on the U.S. Bankruptcy Court for the Western District of Tennessee and was the first African-American woman in the history of the U.S. to serve as a bankruptcy judge. And in 1982, she was elected to the General Sessions Criminal Court, becoming the first African-American woman to serve as a judge in the history of the state of Tennessee. See what I mean about pioneers and groundbreakers. I know of her work in the American Bar Association, where she was the first African-American woman to actually be elected to the position of secretary of that 400,000 person organization. She has done judicial training on behalf of the rule of law in what I count as 5 continents and at least 25 countries. And for UCI in particular, one of the awards, I will just mention this one, is that she got the Margaret Brent Award of the American Bar Association, and our faculty member, Michelle Goodwin, is getting it this year, and we are very proud of that. Next, I turn to the Honorable Richard A. Paez, who was appointed by President Clinton as the Circuit Judge for the United States Court of Appeals in March 2000. He is a member of the court's executive committee and former chair of the Ninth Circuit's Court Counsel Committee on Bankruptcy Appointments. Prior to his appointment as a circuit judge, he served as a district court for the Central District of California from 1994 to 2000, appointed by President Clinton. At the time, he's worked his way up. At the time of his appointment to the federal bench, he was a judge of the LA Municipal Court, where he was appointed by Governor Jerry Brown. He earned his BA from Brigham Young University. In 1969, received his JD from the University of California, Berkeley. Following law school, he went into a public interest career. He was employed by the California Rural Legal Assistance in Delano, California, and in 1974, he joined the staff of the Western Center on Law and Poverty, and then from 1977 to 81, he was employed by the Legal Aid Foundation of Los Angeles, and from there, Jerry Brown put him on the municipal court. Third is the Honorable Johnny B. Rawlinson, who was nominated by Professor Clinton in August 1997 to become a U.S. District Court. She was confirmed in 1998 and became the first woman and the first person of color to serve on the Federal District Court in Nevada. On February 23, 2000, the recommendation of Senator Harry Reid, she was nominated and confirmed for the United States Ninth Circuit Court of Appeals. She was also the first African-American woman to sit on the Ninth Circuit. Prior to taking the bench, she was employed in the office of the Clark County District Attorney for over 17 years. She served as a deputy district attorney and a chief deputy. In January 1995, she was appointed to the position of assistant district attorney, where she supervised civil, family support, and administrative divisions. She is a summa cum laude graduate of North Carolina A&T State University in Greensboro with a BS degree in psychology. She graduated with distinction from McGeorge School of Law, and she received a master's in judicial studies from Duke University in 2016. These are very impressive individuals, and I think we're ready to go.
All rise. You may be seated. Hear ye, the court is now in session. The Honorable Judge Richard Paez, the Honorable Judge Johnny B. Rawlinson, and the Honorable Judge Bernice Donaldson.
Good afternoon, everyone. We'll take up the case this afternoon of Root versus Holpart, and if counsel would take their positions.
May it please the court, I'm Alex Bogus, and I represent the petitioner in this case. I would like to reserve 5 minutes for rebuttal.
Go ahead.
The issue before the court is whether prior restraint on speech through permanent injunction in cases of defamation is unconstitutional. And as the courts have acknowledged for decades, such prior restraint on speech is one of the most repugnant to our democracy and to First Amendment rights. Today, petitioner entreats the court to find permanent injunctions on future speech are unconstitutional in light of the well-established presumption against prior restraints, the inherent overbreadth of permanent injunctions, disregard for the contextual nature of defamation, and the sufficiency of other forms of remedy. As the court stressed in Vance, any system of prior restraint comes to the court bearing a heavy presumption against its constitutional validity. The Supreme Court has likewise been clear and unequivocal in holding that that orders enjoining speech are prior restraint, even if they follow a judicial proceeding. Court orders.
Could I just let me see if I understand exactly where we are in this matter? As I understand it, following the jury's verdict of returned a verdict of defamation and identified the specific statements that were defamatory, it was later determined that the defendant was, how would we say, judgment-proof? What does that mean?
Your Honor, in this situation, the defendant was found to be judgment-proof, meaning in this
I
moment
mean,
in
he has
time,
no money at all?
in this moment in time, he is unable to pay the total of the pay of
That
the
doesn't
judgment.
mean, there's a judgment, though, for $250,000, correct?
Correct, Your Honor.
Why isn't, how is it that was there a finding by the by the judge that he was?
Yes, Your Honor. The district court did find that the defendant in that case was guilty, and the jury awarded a damage award. And unfortunately, the defendant was unable to pay, meaning in this point in time, he is currently judgment-proof. However, being judgment-proof...
So although the plaintiff prevailed, he didn't really, there's no relief, really? Is that right?
In this moment in time, he's unable to recover the damage award, but there is still the inherent value of the declaratory judgment itself.
Miss Bogut, on the, you say he still has the inherent value of the judgment, but doesn't this basically leave the plaintiff without any remedy? I know the court says that you've argued that this is a prior restraint on speech, but if in fact the respondent is judgment proof, and we don't know when he might get funds, there's nothing to keep the speech from just continuing and even escalating, because the person could always say, yeah, they said it was defamatory, but I have no money. And what's to keep that speech from continuing and therefore denying a remedy?
Your Honor, thank you for your question. The remedy in place of the damage award will continue, so there is still a form of remedy, but in regards to the potential future harm of repetition, the fact that there has been a declaratory judgment and the fact that the defendant has already been found to have spoken defamatorily against the plaintiff, that judgment itself is of great value in mitigating the harm that he can do in the future.
Counsel, precisely what is the value of the underlying judgment if he is judgment proof? What is the value?
The value is if the defendant were to repeat such statements or to speak other harmful words, his credibility has been undermined by the judgment itself. The plaintiff has the ability to go on these same social media accounts and to post the findings of the judgment, to post that Root has been found to be a defamer, and the value of his words and whether or not they're going to be able to do future harm is severely mitigated by this judgment.
But that's not a legal remedy, is it?
That is not a legal remedy in the context of some things such as damages. It's definitely a different form of remedy. It is simply the way social relations operate, in fact.
So since the defamation law is not criminal in nature, there really is nothing to cause the defendant the respondent rather, to discontinue that speech. You say his credibility will be undermined, but he's out for vengeance and revenge. So this really does leave the person without a remedy. If we say that there can be no injunction in this instance, isn't that correct?
Your Honor, I would rebut that statement and say instead that there is still the damage award. Although he is currently judgment proof, he could be able to pay the judgment in the future. And this has been the traditional remedy for defamation for hundreds of years. Courts have found since as early as the 1700s that the appropriate remedy...
Let me ask you this question, though. As I understand from the limited record that we have here, that these statements were posted on various internet sites, various social media sites. Those statements are out there, correct?
Correct.
How does how are they ever retracted?
Those statements, in theory, could be retracted by a retroactive injunction as opposed to the current injunction. The current injunction restrains future speech, so it really has no effect on the statements that are already out there. If there was instead an alternative remedy of a retroactive injunction, such as the court used in Kinney v. Barnes, they could require that he take down the statements that have been previously posted and previously found to be defamatory. And in such a situation, we actually are able to protect the First Amendment freedoms of future speech.
But even then, you're addressing future conduct, because assume the statements have already been read, they've already been heard, they've been consumed. So you really are still addressing future actions, aren't you? You're just narrowing the scope.
Rather, instead of addressing future actions, it's only focused on the past action, the past posting. It has no influence over future postings and future speech.
But counsel, if the statements have already been made, how is this a prior restraint then?
Unlike other forms of tort, such as obscenity, defamation is inherently a contextual tort. So the same statements made in one situation may not be defamatory in another. Although the statements made in the specific postings at issue have been found to be defamatory, those same statements could be spoken in a new context, a context without malice, or a context in which no damage is done, and not be legally defamatory. And since this current injunction restrains all repetitions of the statement, both those that could be defamatory and those that could be legitimate, it's overbroad in that it is prohibiting protected speech as well as defamatory speech.
But is it prohibiting prior speech if the speech has already been made?
If we're referring to the posts that are currently posted online, those could be considered past speech. But if we're referring to anything that he speaks from this moment on forward, speaks aloud, posts anew, any of that would be new speech.
Even if it's exactly the same content?
Even if it's the exact same content, because it's being spoken in a new context. And each one of those statements are individually their own. For example, if this morning I woke up and said, "The sky is blue," it might be true today, but tomorrow it would be a new statement, and it might not be true. It might be a gray, cloudy sky in which we have a whole new statement in a new context with a new meaning. Given that contextual nature of defamation and of speech in general, that's what makes the inherently restrictive nature of a permanent injunction in a defamation case so dangerous.
So let me ask you this. The First Amendment will tolerate an award of $250,000 in damages for speech, correct?
Correct.
So why won't it also tolerate an injunction that seeks to enjoin use of the same defamatory statements, or to prohibit use of the same defamatory statements?
Such has been the state of the law for hundreds of years, that the courts have found that monetary damages that redress past actions are the appropriate remedy for defamation, as opposed to injunctions, which are an equitable remedy, being imposed to restrict future speech. With a monetary award happening after a defamatory speech has been made, it's applying a punishment to something that's already occurred. An injunction that prevents future speech is restraining an ability to make a choice in the future.
As Judge Rawlinson just said, though, it's just, the injunction here only dealt with the exact defamatory statements that the jury found to be defamatory.
Correct, Your Honor. However, those statements can be spoken anew in a new context. The fact that the past statements were found to be defamatory does not mean that they have no value or no ability to be protected in the future.
But does the First Amendment, though, address context? Doesn't it address speech? I understand you're saying that the speech can be uttered in a different context. Perhaps it can be, it can be suggested, going back to your sky example. But the same words that have been spoken today, the injunction says, you may not speak these words tomorrow or next week or next month. So since we're talking about the same speech, why would context alter the analysis?
Yes, thank you, Your Honor.
The speech is already out there. It's just repeating this, enjoying this repeated speech.
Thank you, Your Honor. This repeated speech, as I've implied with the context, can be new and can be protected. For example, in the future, if Tim Halpart does prove to be a fraud, in that context, the statement would no longer be defamatory. This current injunction, as it stands, would prevent Root from even so much as reporting to the police Tim Halpert is a fraud if he were to find new evidence. But in that context, it would have been protected speech if it were not for this injunction.
But it would not prevent him from saying Tim Halpert. It would not prevent a factual recitation. So in that instance, I think that the analysis there falls down when you're talking. The injunction doesn't prevent the reporting of facts. We're talking about reporting defamatory things.
As the injunction is currently worded, it prevents all repetition, whether of fact or of anything. By the collateral bar rule.
The injunction addresses these statements that are conclusory or defamatory in nature. I'm saying if the defendant says, if the speech is Tim, he overcharged customers by $67 on these series of items, that's a factual thing. And you're saying he could not report that to, the FTC or whomever because of the injunction.
Because of the injunction, he wouldn't be able to use the specific phrase in the injunction, Tim Halpert is a fraud. He could use creative language to say something other than that to convey the same idea. He could report facts. Correct.
The injunction does not say he cannot report facts. And you're saying if he finds later that he's a fraud, the injunction does not prevent him from reporting underlying facts.
Correct, Your Honor. Thank you.
But doesn't that undermine your argument that this is a prior restraint then?
That would still not make this not a prior restraint because it is still restraining him from saying the specific statements at issue in the injunction. He still could not say Tim Halpert is a fraud in any context, in any way. He can report those underlying facts, but he cannot say that statement. It's restricting his ability and his freedom to make these statements, whether or not they are true, whether or not they should be protected. It is restraining his ability to speak them again.
But a jury's already found that they were defamatory.
In the specific context of the past postings, but that cannot be used to make a judgment about what his future, what the future will mean for that.
What future context would suggest that Halpert is a thief? Would not be defamatory.
If Halpert became a thief,
but what circumstance? You keep saying that there may be some future circumstance.
Yes, Your Honor.
Where that statement is made and it's not defamatory.
Yes, Your Honor. In a future context in which Tim Halpert does commit theft, or even if it was in a context where there is no damage done by the statement in theory, according to the law of defamation, proof of damage is one of the required elements, but this injunction takes no account for any of the elements of defamation. It only accounts for whether or not the statements are spoken, regardless of the context, regardless of the damage done, regardless of any other element of even truth. So in essence, yes, Your Honor?
So, Ms. Bogus, what is your best case to support the position you're currently advocating? What's your strongest case?
The strongest argument, I would say, is relying on the court's, the case law from this very court. The court has found consistently since the 1930s that even...
Give me the name of the case that you're relying on.
Near, for one, Near from the 1930s specifically held that even in the case of a person who has previously been found liable for printing defamation, that it is not sufficient to prevent future statements.
It's interesting that you go back to the 30s. Because here we have, certainly using your word, context and circumstances. We didn't have the internet. We didn't have all this social media and all that then. So you have no case since the 30s that you think supports your position?
Oh, no, Your Honor. I have consistent cases up through the history since then. Near is just simply what I turn to since it seems to be the grandfather of many of these cases, from Nebraska Press Association all the way up to Kinney v. Barnes in the Texas Supreme Court. And even though situations have changed with the advent of the internet, this court has held in Reno versus American Civil Liberties Union that overbroad restrictions
Just finish your remarks, and then I'll give you a little rebuttal time.
Of course. And just simply that the court in Reno v. American Civil Liberties Union specifically held that the First Amendment scrutiny should not be lessened simply because speech occurred online, and that speech online deserves the same level of protection as speech before the dawn of the internet.
Thank you, counsel.
Thank you, Your Honor.
Okay. We'll hear from respondent.
May it please the court, I am Emily Livermore on behalf of respondent. Petitioner Dale Root's incessant defamatory statements made across numerous blogs and online platforms have caused respondent's lumber business to seriously suffer. He's seen a significant decline in his sales, key relationships with clients have been damaged, and seeing as he cannot recoup these financial losses based on petitioner's judgment-proof status, this injunction is the only means he has to prevent permanent, irreparable harm to his and his company's reputations. So today, I urge the court to affirm the Ninth Circuit's decision in upholding this injunction and further find that injunctions that specifically enjoin statements that have already been adjudicated to be defamatory are constitutionally permissible, so long as, number one, monetary damages are inadequate due to a strong likelihood that the defamer
Let me ask you this. I asked this of your opposition counsel. So there's a judgment, correct, of $250,000.
Correct.
And it's a good judgment, right? He might win the lottery next week, right?
Correct. Petitioner.
And you could collect on that judgment.
Petitioner could win the lottery and pay off that judgment, but ultimately that monetary judgment isn't sufficient to repair the harm done to
Well,
respondent
but we've said
in this
traditionally,
case.
as your opposing counsel said, that traditionally damages are the remedy.
Traditionally, damages are the remedy, but we must recognize that we're living in a world today where someone can defame someone else to a global audience within a mere matter of seconds from their phone.
Ms. Livermore, in determining what you said that the judgment is not sufficient, but the jury heard the facts and they determined that this was a sufficient amount of damages to remedy the harm to your client. So how can you say that it's not sufficient? Because they, in their reasoned opinion, decided after hearing all the facts that this is the number.
Correct. The jury did come to the $250,000 number. However, in doing so, they failed to consider, and this is something that the district court notes in its order granting the injunction, the jury failed to consider the potential future injuries that could occur due to petitioner's continued defamation, and also the injuries done to respondent's reputation, his business's reputation, and the damages that have been done to his relationships with key clients.
How do you know that the jury failed to consider that?
Based on the fact that the district court pointed it out, and because these are harms that cannot simply be repaired with a mere financial sum. Rebuilding one's reputation and rebuilding the relationships that have been damaged with clients is going to take time for respondent to do, and he's going to need to be able to do that without petitioner continuing to defame him, specifically online, using the defamatory statements that this injunction is specifically targeting.
So is it your position that any time the jury fails to consider the evidence that the plaintiff thinks should be considered, a prior restraint is appropriate?
No, I don't think that any time the jury fails to consider what the plaintiff thinks is appropriate. However, I think when the jury fails to consider the possible damages that can be done that are not simply repaired with financial amounts, that's where monetary damages become, in the words of eBay v. Merck Exchange, an inadequate remedy, and an alternate one, namely this injunction, is required to prevent the continued and irreparable harm done to people like respondent.
Ms. Livermore, if we decide that because of the judgment proof of the petitioner here, that that economic damages or financial damages is insufficient, are we setting up a different First Amendment application and interpretation for poor people as opposed to people with means?
Thank you for that question, Your Honor, because I do want to clarify that I'm not suggesting that an injunction of this sort is warranted when someone is judgment-proof or based on any sort of economic status. Rather, I'm suggesting that an injunction of this sort is warranted when there's evidence that the defamer will be undeterred by monetary damages, or again, that the monetary damages would be inadequate. And here, the monetary damages are inadequate because even if there was this judgment against petitioner that he could potentially pay off if he acquires the means to do so, this is unlikely to deter him in the way that an explicit order forbidding him from repeating the key statements that resulted in all this harm is likely to do so, especially considering if violated, it could result in even more serious consequences.
He already said that he was going to continue, so how would the prior restraint deter him?
He said he would continue. However, this injunction is specifically telling him not to repeat the key statements that have been the direct result of the harm done to respondent. And if this injunction is violated, it could lead to even more serious consequences for the petitioner, unlike the monetary damages, which he may or may not be able to pay off at some undefined point in the future.
But I thought you said the fact that he was judgment-proof didn't propel your argument.
Correct. The fact that he's judgment-proof should not warrant issuing the injunction here. In regards, going back to the fact that would this injunction actually be a deterrent, I can address that because I do recognize that in light of petitioner's commitment to continue to defame, there is a possibility that the way this injunction is worded, petitioner could circumvent it by being strategic with his language. However, the injunction is targeting the statements that have done the most harm and the statements that petitioner has repeated again and again. And an injunction doesn't need to prevent every possible future harm to be an effective remedy here. As this court said in United States v. W.T. Grant, the purpose of an injunction is to prevent future violations. The function is to afford preventative relief. It's not necessarily to make the respondent whole again.
So let me ask you this.
So Ms. Livermore, what if the statements alleged that have been found by the jury to be defamatory, what if in the future those statements become true and the injunction is in place? Doesn't it put an unreasonable burden then on the defendant to go back and somehow get relief from the injunction in order to utter a truth? It was defamatory at the time it was uttered, but all of a sudden in the future, this becomes true. What is the remedy for the defendant then to go back and be able to speak truth?
Thank you, Your Honor. I have a couple responses to that. Number one, I don't deny that this would place some level of a burden on petitioner to go back to court to have the injunction modified. However, this is a burden that courts have said is appropriately placed on defendants in cases of permanent injunctions. Specifically, we could look to the Fifth Circuit's decision in Brown v. Petrolite. The court there was examining a permanent injunction barring defamatory statements made by an oil company against one of its competitors' products. And the Fifth Circuit explained there that if the circumstances change, if new material evidence arises, the proper procedure is that the defendant goes back to court to have that injunction modified. My second point to that would be that the balance of rights here ultimately favors the respondent. So if the circumstances were to change, petitioner has this opportunity to go back to court and have the injunction vacated or modified, but for respondent, he has no alternative means of recouping the loss resulting from his rights being violated as a direct result of petitioner's illegal conduct. So
your opposition counsel stressed that defamation or defamatory statements are context specific. So how do you, is your whole response is it's his burden if the context changes to go back to court? That's what the...
Correct. I'm saying if the context were to change, it would be on the petitioner to go back.
The problem with that is, though, the context suggests that the statements that you're essentially, it's a prior restraint. You're censoring his speech.
Well, because this injunction is only enjoining the specific statements found to be defamatory, it's really targeting what will most likely be unprotected speech, because based on these circumstances, based on what we know, in all likelihood, the circumstances won't change in a way that would render these statements protected. And if petitioner did restate them, they would most likely be unprotected. And this court has upheld certain restrictions on speech with the justification of deterring continued unlawful conduct.
Well, you know, this one of the statements was avoid Holbert Wood Company unless you want to be scammed. That sounds pretty context specific, doesn't it?
Yes, it's context specific. Again, if the circumstances were to change to make that statement true, petitioner has the opportunity to go back to court and have the injunction modified. But in all likelihood, the circumstances won't change in that way, and the injunction is ultimately serving to deter unlawful conduct, which is what we've seen the Supreme Court use to uphold certain restrictions on speech. We could specifically look to this court's decision in Madsen v. Women's Health Center, where certain restrictions on speech were upheld principally because they burdened no more speech than necessary to deter the continued unlawful conduct of anti-abortion protesters. And while the injunction in that case was a bit different on its face, as it was placing time, manner, and place restrictions on the speech, we can find further support for deterring unlawful conduct being a supporting reason to uphold injunctions like this in this court's decision in Torrey v. Cochran, where the Supreme Court was evaluating a permanent injunction that enjoined a defamer from making certain defamatory speech about Cochran and his law firm. But before this case reached the Supreme Court, Cochran passed away. And this is important because there was a finding that the defamation was intended to coerce Cochran into paying off the defamer. So once Cochran died, there was no longer that risk of coercion. There was no longer the potential for the injunction to prevent continued unlawful conduct, and that's the primary reason we see the Supreme Court vacate the injunction in that particular case.
Okay, in this case, why isn't it an appropriate remedy to rather than restraining or suppressing, if you will, speech, to have more speech to clarify, rebut, and overcome the speech? So why can't respondent just pay for advertisements and posts that provide more laudatory comments from customers on the social media accounts to contract the false and defamatory ones? Why isn't that an appropriate remedy rather than restraining future speech, but require them to put forth more positive future speech?
That would not be an appropriate remedy here because there is already this burden on respondent to rebuild his business and rebuild his reputation as a result of petitioner's illegal conduct. So further requiring him to expend even more money on advertisements or to continuously monitor the internet for continued defamatory speech for petitioner would be unreasonably burdensome on respondent. And again, it's a result of petitioner's illegal conduct that got us here in the first place. I'd like to also address why this permanent injunction is an appropriate remedy pursuant to eBay v. Merck Exchange. The court there, of course, developed 4 elements that respondent would need to prove to ensure that a permanent injunction was proper. And all 4 of those elements are met in this case. First, respondent has suffered irreparable harm. I've touched on this already, so I won't belabor it. But again, his reputational damage, the damage to relationships with clients, these aren't things that can...
That irreparable harm, though, has been compensated.
The irreparable harm cannot merely be fixed with a monetary amount.
Well,
while he has seen a decline in his sales and there has...
That's what the trial was all about.
Yes, the trial, and again, the jury did assess the $250,000 in damages to repair that harm, but that did not take into account these irreparable harms the continued defamation could cause, as petitioner, as expressed, he plans to do.
But isn't the point of defamation damages to compensate for the harm, as opposed to focusing on the irreparable portion of the damages.
For defamation, yes. And I'm arguing that in this context, this is why an injunction is warranted in this particular context, specifically because petitioner has demonstrated this commitment to continue to defame. And in our widely interconnected technological world that we live in today, it makes it much harder to protect what Justice Stewart has described in Rosenblatt v. Bayer, the right of a man to the protection of his own reputation from unjustified invasion and wrongful hurt, which reflects no more than our basic concept of the essential dignity and worth of every human being.
Why wouldn't just a limited injunction ordering the respondent or the petitioner to take steps to remove all statements from the internet? Why wouldn't that just be sufficient to address his harm?
While respondent would appreciate that type of order, because yes, there are still posts that remain live to this day that contain these defamatory statements, there are a couple reasons why this isn't enough. First is the extreme harm that has been done to respondent, to his business reputation and these relationships again, that merely taking down the post is unlikely to repair that.
Well, it seems like the money would take care of that.
The money could definitely make up for the sales that have been lost. However, having additional funds is not going to instantly repair the relationships that have suffered with respondent, his clients, and this reputation that has suffered as a result as well. In light of the heightened risk that defamation carries in the world we're living in today, this warrants a form of preventative remedy, namely injunctions, in these unique situations where the defamer has made some sort of commitment to continue to defame, and again, where this defamation has caused the plaintiff irreparable harm, because monetary damages won't be enough in those cases. Returning to the elements under eBay v. Merck Exchange, I've already addressed why this is an inadequate remedy at law, but I can also argue why, considering the balance of hardships here between petitioner and respondent, there isn't an undue burden placed on petitioner. I know we've already addressed the reality that there is some level of a burden placed on petitioner if the circumstances change and he must go back to court to have the injunction modified. But this does not outweigh the burden that is placed on respondent to rebuild his business and his reputation as a result of this illegal conduct. And the final element, the public interest is not disserved by this injunction. The Supreme Court has said that defamatory speech, it carries very little social value. In the words of Kaplinsky v. State of New Hampshire, such utterances are no essential part of any exposition of ideas and are of such slight social value that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Ultimately, this is not only an appropriate remedy under eBay, but it's an effective one in this particular case because, again, while it may not prevent every possible future harm, it does target the statements that have caused the harm and the statements that petitioner has repeated again and again across various online forums.
Why doesn't the respondent, your client, just post the judgment on his website? Or on Facebook or whatever social media tool he has.
Respondent could post the judgment. He could respond to petitioner's posts that are still live now with the judgment. But that ultimately won't be enough because petitioner has made this commitment to continue to defame. So if respondent has to go and track down every time petitioner continues to make these statements, as he's said that he will, posting one judgment on one website is not going to be enough to repair the reputation of one of the largest lumber companies in the state of California. I'd also like to, as my final note, while traditionally equity would not enjoin libel, I want to highlight that courts have moved away from this traditional maxim to a more modern one that says defamatory speech may be enjoined after a specific finding that the prohibited speech is false. We see a discussion of the transition from the traditional approach to the more modern one in the Kentucky Supreme Court case Hill v. Petracek, and we also see the Supreme Court affirm it in Pittsburgh Press v. Pittsburgh Commission on Human Relations. So for all of these reasons, I urge the court to uphold this injunction and find that injunctions that are specifically enjoining statements already adjudicated to be defamatory are constitutionally permissible.
Okay, thank you very much. Why don't we put 2 minutes on the clock for a little rebuttal? Oh, shoot, 5 minutes, whatever it was. She reserved.
Yeah, take away 3
Yeah,
minutes.
took away 3 minutes mistakenly.
Pardon me. May it please the court. I would like to focus on 2 points in particular. Respondent has underestimated the burden that this injunction will in fact be placing on the petitioner, and also misunderstood the overall public interest weight of the judgment itself. The burden that this injunction will impose on petitioner is one that courts have already found to be the very definition of censorship. As the court stated in Neer, forcing a party to affirmatively prove to a judge that their future statements are true and published with good motives and for justifiable ends is the very essence of censorship. And that's what this injunction will force upon petitioner if he is to use any of these statements in the future. To have to come back and stand before a court and to go through the process of getting governmental approval to make speech is in fact censorship. It's chilling on his ability to make future speech, and it is in essence something that can just not be squared with the First Amendment. And on the topic of the public interest, as we've discussed, the world has changed as the internet has continued to evolve and there's a more interconnected state. And in light of such, the improving such an injunction and allowing it to go forward and to set a precedent of allowing such injunctions can have an incredibly broad effect. More people are finding themselves on the end of litigation over defamation. It's becoming more and more prominent as social media expands and speech is made occasionally just offhand online that can bring someone into court.
It seems like with the advent of the internet and all the social media that takes place, it seems like that should be a factor in thinking about whether or not a narrow, limited injunction might be warranted.
Thank you, Your Honor. Pardon me. It is something that needs to be considered, but it needs to be considered for the effect it can have on chilling speech. Allowing these injunctions and having a wave of injunctive relief lobbied against people who have made poor decisions to post online can reach out and affect a tragic number of people in our population.
But isn't it true that you can't just consider the consequences one way? Don't you have to consider them both ways? And as the Chief Judge said, it would call for more scrutiny. You're saying only because of the chilling effect, but we also have to consider the other aspects, don't we?
Yes, Your Honor. What I'm attempting to communicate is that we can't ignore the chilling effect. The other elements have been at least briefly discussed by the respondent, but the chilling effect and the far reach that it can have across the population isn't something to be ignored either. There has actually been there's been a turn across courts, specifically in regards to criminal defamation. I don't want to stray off the topic too far, but there has been an increasing number of retraction of criminal liability for defamation across the states over the past 60 years, beginning with the court's decision in Ashton v. Kentucky. As such, this reflects the overall trend away from trying to criminalize defamation, and allowing an injunction to stand allows for an essentially criminal punishment for defamation. If it's repeated and they're held in contempt of court, suddenly people can find themselves going to jail for repeating a statement that wasn't good or truthful. And although this isn't a good thing, this isn't something that we want to promote, to speak statements that aren't good or truthful, to impose criminal liability and to impose criminal sanctions against people imposes such a chilling effect that it's dangerous to the public at large. In light of that concern, the tip of the public interest is not as clearly in favor as respondent would have you believe. As such, it needs to be acknowledged that the burden that this injunction places on the respondent amounts to censorship. It's going to prevent him from being able to make future speech without getting affirmative government approval beforehand. And it poses a great threat to the public interest, as it can become, if it were to become a more regular remedy, it will slowly begin creeping its way across the nation as more and more people find themselves on the wrong end of lawsuits over social media posts. If there are no further questions, I will cede my time.
Okay, let's see. I don't think there are any further questions, so thank you very much. Okay, the court will be
All rise. Court is in recess. You may be seated.
As the judges take some time to deliberate, I'd like to take this time to thank all the people who have helped us bring this competition to life. I'd like to start off by saying congratulations and thank you to all the competitors who have participated in this competition. We appreciate your poise, hard work, and professionalism. We're so proud of you, and we hope you're proud of yourselves. I'd like to thank our professors who graded 20 appellate briefs and judges and practitioners who presided over 53 sessions of oral argument over 19 nights. Thank you to all those practitioners, professors, and judges. Additionally, thank you to all the 1L bailiffs who kept time throughout the competitions and 1L fellows who didn't hesitate to help us in any way that they could. I'd like to thank our event coordinator, Jillian Henry, and her assistants in running this competition. Thank you to Professor Paul Hoffman and Attorney Matt Timon for providing brief writing and oral argument training for all of our competitors. I'd like to thank our advisor, Professor Krosky Roberts and Dean Garth, for their continued support of the program. Finally, I must say a huge thank you to the other 5 members of the board: Hamaseh Sarushian, Ian Mayer, Stephanie Sneddon, Emily Yu, and Sophia Papayannou. Thank you. Running this competition takes a tremendous amount of dedication, time, and heart, and it wouldn't have been possible without each of you. Without further ado, please join me in welcoming Professor Krosky Roberts, who will be announcing the winners of the brief and the combined score awards. Thank you.
So I get the fun part. So I have to say, I just want to very quickly thank this board. I know you just named everybody, but I want board members, I know only a few of you are here, but please stand up just for a second so they can see these board members. Yeah. You have no idea, if you have not tried to run something like this, you have no idea the year that these amazing individuals have had. This is just this final culminating event, but they have been working hours behind the scenes for months and months and months to pull this off. And it's just been, oh, can people, are you going to move it for me? There we go. And I am just so incredibly proud. Usually I'm so loud you don't even need a mic, so I'm surprised. I'm just so incredibly proud of you all. So thank you so, so very much. None of this could have happened without all of you, and I didn't want to just let Bailey say that because Bailey didn't thank herself. So I wanted to make sure to do that. So the judges are deliberating to decide who the best advocate and second best advocate will be for today. I get the wonderful honor of giving out all the rest of the awards. And there are about 1 million down here, so just bear with me. So let's see, I'm gonna start with the, let's see, these are the awards for Best Brief, and we've got second runner-up, first runner-up, and Best Brief awards. So for those, since we have a bunch of, by the way, welcome admitted students. I'm so happy you're here. This could be you someday. For those who aren't aware of how this works, the students compete orally individually, but they wrote the briefs in teams. And so when I'm giving these away, you'll be seeing teams who win each of these briefs. So the second runner-up, and if you are here, please come up here to get your awards. The second runner-up Best Brief awards go to Rob Brown and Manisha Malhotra. Do I have somebody coming? All right. Yeah. Yay. And do I have, here you go. And I think you might want to step up so you can get a photo. There will be photos and photos. All right, thank you. And then, let's see, what do I have next? I've got the first runner-up Best Brief Award goes to Ryan Riedmuller and Samantha Berry. Now they're breakable, careful. Oh, fine. And the Best Brief Award goes to Allison Greenberg and Letitia Smith. They give me breakable things, which is a little scary, but.
I love breakable things.
All right. So here we go.
If I can get this off the piercing. Oh my gosh. My mom will be so proud.
Thank you guys. Congratulations. Thank you so much. The next set of awards are for a combined Best Brief and Oral Score combined together. And the second runner-up for Best Combined Brief and Oral Score is Kate O'Rin. And then let's see. The runner-up Best Combined Brief and Oral Score Award goes to Lena Sajapur. I swear I'm almost done.
Thank you.
Congratulations. And you might have heard from this person today a little bit already. The Best Combined Brief and Oral Score Award goes to Emily Livermore.
Thank you.
And now what we do is we awkwardly sit here and wait while the judges deliberate, and then we will come back and they will come back and announce from the bench who our best overall advocate and our runner-up best advocate will be. But I just want to tell you right now that I was just so, because I have the stage and this captive audience, I was so proud of our two oralists today. So in my mind, they've both already won. All right.
If everyone can please get seated, the judges have finished deliberating. Thank you.
All rise. The court is back in session. The court is back in session. You may be seated.
Well, let me just say, on my behalf, and I'm sure my colleagues will say this as well, thank you very much for the invitation to participate in this final moot court session. It's always nice to visit one of the law schools in Southern California. I actually attended 1 year here at UCI in 1967, 68. And there was only like 5,000 kids, or not even that, I don't think. There may have been 2,000 kids at the time. So I always enjoy coming back here. In any event, thank you very much for letting us participate in this particular session. It's nice to be back doing live performances. For so long, all of us participated in oral arguments over Zoom and got the job done, but it's not very exciting. It's always nice to be in person and to see people in live. That was good. At our court, at the Ninth Circuit, we're just getting back to live arguments, and it's been nice. So a little bit about this argument that we just witnessed. Before we make any announcement regarding the overall winner, and it's like when we started to talk about today's session with the moot court board members, I asked, do we have to select a winner? And the answer was yes. So, but before we get to that, so let me tell you my own view about oral argument is I like to think of it as a discussion with the lawyers about the issues in the case and concerns that I have about the case. And they may be concerns that I'm thinking might be of concern to my colleagues. They may be of concerns that I'm literally nervous about or troubled about in the case. But I always like to see it as a discussion. And part and parcel of that for me is the dialogue with the lawyers, and that is having the opportunity to ask specific questions or general questions, and to see and hear their responses. Did they understand the question? Are they able to respond to it directly? Are they tiptoeing around it? Are they trying to avoid it? They don't understand the question, whatever it might be. And so for me, that's a really important thing. And here, my perception of what we saw today was that both of the advocates today were quite capable of answering our questions, although there was some difficulty here and there on various questions that were asked, I thought. And it's hard for an advocate to stand up there and suddenly be fronted with a question which they haven't had an opportunity to think through, although I'm sure the questions we asked may have been tossed out to them in all the preparatory sessions that they had before today. I'd be curious if that's the case. But I thought both of the advocates were quite good at responding to our questions. Not in every instance, and I didn't take specific notes to pin one down and say, that this was an inappropriate response, because I don't think any of the responses were inappropriate. Some were more effective than others. And for me, what it demonstrated, their answers to the questions that were posed by Judge Rawlinson and Judge Donald were that they understood the case, they understood the issues at hand. They offered an approach for us to resolve the case in their favor. Whether you think their arguments were persuasive is a whole other matter. But they did offer some way of looking at the case that would allow us to come out in their behalf. So on that, and I'm just going to leave it at that general matter for the moment. Well, Judge Rawlinson and Judge Donald offer maybe a few more concrete observations about what we saw this afternoon. So let's see, I don't know, Judge Donald, would you like to go first?
Well, that's fine. Thank you very much. Unless Judge Rawlinson, who is my senior, wants to go.
Oh, Judge Rawlinson.
No, that's quite all right. I would never presume to go ahead of Judge Donald.
And I only, for the students, I only admit that in terms of her service. She was appointed to the appellate court ahead of me, so yes. Thank you. Okay, well, let me proceed then before I put my foot in my mouth again. I want to join the Chief Judge in saying what an incredible pleasure it is to have been invited, and I was so looking forward to being there with you and being there with my colleagues in person. But we know that life happens, and I'm just thankful for the staff who arranged for me to appear via Zoom. Because this case is interesting. The arguments were wonderful, and you advocates showed great facility in presenting the case and arguing the issues. I want to make some general comments, and then I will make a couple of specific comments. First of all, I want to commend you for making it to this point. And I like to tell people, and I believe this to my core, that at this level, yes, I will be a prevailing advocate, but there are no losers in this moot court competition, because you are well prepared. You have experienced and survived the rigors of advocacy, and you've demonstrated your excellence in your craft. And as a sitting judge, I could only hope that we had this quality of advocacy each time I don the robe on our circuit and hear arguments. You all are well prepared and you're to be commended for that preparation. You did well in many respects. And I want to just emphasize this because we were in an artificial environment today. You all knew this problem. You knew the other side's position. You've argued it. I don't know whether you were arguing today the side that you argued throughout the competition, or whether you were given a side that you had not argued as many times as you had another. But one of the things you did, no matter who gave you a question, even if we were at times both starting to speak over, if two of us were starting to speak over each other, you stopped and gave us an opportunity to lodge the question. You listened. You recognize that listening is a skill the same as talking. You gave the court eye contact. No matter who gave you the question, when you started to answer, you took in the entire court. And that's appropriate. I tell you, I find it offensive when advocates come before me and they believe there's a person on the court who is sensitive to their position, and they train on that judge and argue their case to that judge. That is offensive. You're arguing it to the court as a unit, as an institution. And when you get a question, no matter the judge it comes from, you address that answer to the court. And you maintain eye contact. I could see that you moved and took in the entire court in your answer. You both were well prepared in presenting your case. You knew the cases, you knew the arguments, you knew each other's arguments. You know, I could tell you not to be nervous, but when you're up in front of your peers, when you're up in front of the court, you're going to be nervous, and you just need to develop techniques to still yourself so that you don't show that. And I will say that there were times when I could detect some nervousness, but it was not extreme. And I want to just indulge you by telling you that we had an oral argument in our court once. We were hearing oral argument at the law school, and there was the petitioner was someone who had argued cases frequently in various courts, had even argued at the Supreme Court, was very knowledgeable, very experienced, and was very steeled when he came before the court. The respondent in that case had not had a similar experience and was very visibly nervous. And I asked him, the respondent, just a basic question, one that should not have engendered any real discomfort. And he stopped and stared at me, and then I could see him sort of tilting. And when I realized what was happening, I yelled to the marshals to catch him. He's going to fall. Well, they apparently were not in the same zone I was in, and so they did not catch him in time. He fell and hit his head, and the press was there and all the students. So I say this to you because you may be going before a court that you've never appeared before for this argument. Go into the court, the day before, and just stand there at the podium if you can, and just familiarize yourself with those surroundings, and do whatever it takes you to do to get comfortable in that space, so that when it is lights, camera, action, you're ready to go, and you found the necessary management tools to still those nerves. Miss Bogus, when we were asking you questions, when your time ran, you got the signal, you were very respectful of the court, and you asked the question, may I please complete my statement? And the judge, the chief judge said, yes, you may. Now, you didn't know he was going to deduct 3 minutes from you initially, but, and so, but he fixed that. But that's what you're supposed to do. You don't, when the light goes on, you don't just keep talking. You ask for permission to complete your statement. He gave you that permission, and you didn't try to get in extra things. You completed that statement, and then you yielded the floor. You also both demonstrated that you recognize that questions are your friends, because the judges are getting at things that they may want to clarify. Sometimes they're giving you hypotheticals, and sometimes the questions can be a little bit convoluted, and you have to try to figure out what the judge is really asking. You didn't have that much of a problem with this, but in real life, if the judge asks a question and you don't understand that, you can ask them to please clarify, to please repeat, or please do something. But if you don't understand it, don't try to answer it in that current format and hope that you're hitting what the judge is asking for. It's okay. And I will just tell you, while you all didn't have this issue, when you're in real life, make sure that you go back and check all of the cases you're going to rely on the evening before you record, because you want to make sure nothing has happened that's going to surprise you. The judges are going to have computers on the bench. They're going to have law clerks who are in the chambers, and they're going to be following what you're doing. And so you want to know the latest up-to-date authority that may be out there. You were able to pivot throughout your argument. The one point I would say to you, Ms. Livermore, is whenever you're going to discuss a case, always give the name of the case. You did that most of the time, but when you talked about the Fifth Circuit case, and I know this is an artificial environment, you didn't give the name of that case because you knew that we all knew the case you were talking about. But in real life, if you're going to talk about a case, don't just give the circuit, give the name of that case in addition to the circuit, so that the judges and the audience and everybody, the record, knows the case you're talking about. So I congratulate both of you. You did a great job. And I will yield now to Judge Rawlinson.
Thank you, my esteemed colleague. I am also delighted to be here. It's really interesting. I never thought about who the other members of the panel would be before I came here, and I was talking to the young ladies who graciously agreed to escort me here after they found me in the hotel. I was in one spot and they were in a different spot, but we eventually met up. And I was saying, who else is on the panel? And they said, Judge Donald from the Sixth Circuit. I said, Judge Donald, we've been friends forever. So that was a pleasant surprise. And then I said, well, who else is on there? And they said, Judge Paez. And I said, we've been colleagues for 20 years. So it was really wonderful to sit with these esteemed judges. They're both well respected. And so it was really a pleasure to sit with them. Judge Paez and I have sat together on many panels, and we've been able to come to resolution on the cases. And so it was really just like old times. We sat recently together on a case, so there was not much lapse with us. And of course, Judge Donald is a judge's judge, and so she helped us to reach our decision as she normally does on the panels that she was on. I won't repeat the things that my colleagues have said, but I just wanted to really reiterate the quality, the high quality of the argument that was here today. You should feel very proud of the fact that you mastered the facts in this case, you mastered the law in this case, and you were able to get up here before a crowd and articulate your positions very well. I thought both of you had excellent eye contact, and I check for that. And sometimes litigants have the inclination to look away when the judges look at them, but you both maintain the eye contact, which is very powerful. That is really a sign of confidence when you maintain eye contact. So that really resonated favorably for you. You were unrattled by the questions. You didn't pause. You didn't have the deer in the headlights look that we get sometimes when we ask questions. I oftentimes will ask a question. If I disagree with your argument, do you lose? And sometimes they have no idea what to say. They just frozen in the spotlight. So I really think that you all did a good job of maintaining your composure. And I'm like Judge Paez. I'm curious as to whether or not you anticipated the questions, because if you didn't, you did a really good job of acting as if you had already anticipated the questions, which was very, very impressive. It's really unfortunate that we have to pick a winner, because you both were so good, and this was a really tough decision for us to make. But I just wanted to make a couple of specific comments. Ms. Bogus, I was impressed particularly by the fact that you were giving distinguishing reasons for the prior restraint cases and saying why those cases should not carry the day. You were very persuasive in your arguments, and I thought very creative. Ms. Livermore, I was particularly impressed by the fact of your smooth delivery. You had very few verbal tics in terms of saying or like, And so that was a really impressive presentation because most of us have verbal tics, and it takes a lot of practice to overcome those, and it shows that you've really practiced on that. I also like your good use of the cases. It's really important when you are arguing before a court that you let them know you have a grasp of the cases, because that's our stock in trade. That's what we're going to use to decide the case. So if you let us know that you know about the cases and you're able to discuss those with us in a conversational way, you've gone a long way toward winning your argument. So congratulations. Thank you for having me here. It's been a real pleasure. I wanted to say I've hired a UCI graduate from the inaugural class, and so I'm not unfamiliar with the work of the school, and I appreciate the work that the school is doing here to train future lawyers.
Well, I think, given the hour, we might just move on. Although I would like to say that I also agree very much with Judge Donald and Judge Rawlinson in the quality of the presentation that we witnessed. You know, sometimes in all the arguments that we see at our court, I mean, there are times when it's like, you know, what happened here? So what we saw today was just terrific. So everybody should be very pleased. Okay, well, with that, you know, and as I said at the outset, it's unfortunate that we have to pick a winner because we thought that both advocates were just really terrific, but we're going to do what we were told to do, so here goes. So the winner of this year's moot court competition is Emily Livermore. This is Alex.
While Alex is coming up, I just want to say that, you know, once again, you see that these two are really class act. I mean, watching Ms. Bogus, she's just so enthusiastic in her support for her advocate, and that is professionalism, that is class, that shows that these people have bright futures.
Absolutely.
There can be more photos, I think. So should we close it and then pictures after? Okay, I get to make the final remarks, which is when you're at a law school as a dean or faculty or staff, when you have a day like this, you're so proud of your students. So really, I'm honored to be able to listen to that. And I want to say, I'm really proud of our judges. That's extraordinary how you really rose to the occasion for us and really asked just the right questions and really made them jump. So thank you very, very much. And also for the very helpful remarks afterwards. I think we were really lucky to have you. So there'll be some photos up here, but there also will be a reception out there. So you may proceed to the reception. Thank you.
Okay.